Good afternoon, good morning, and good evening to everyone, and welcome to the second day of our conference, the New Horizons, the Future of the United Nations Convention on the Law of the Sea. Can I commence today, as I did yesterday, by acknowledging and celebrating the first Australians on whose traditional lands we're meeting virtually today, and especially the Ngunnawal people in Canberra. And can I pay my respects to the elders past, present, and emerging. So without further ado, I'm going to now introduce our keynote speaker, my dear friend and colleague, Professor Karen Scott. Karen's got two roles, I guess, in this particular setting. The first is as the president of the Australian New Zealand Society of International Law, but secondly, as one of the world's leading scholars and researchers and entrepreneurs, one could say, in terms of Law of the Sea scholarship. And I mention that because Karen has, as many of you know, in the last few years taken over the editorship of the journal Ocean Development and International Law, which many of you will be aware of. Karen holds numerous other editorial positions, and Karen's Law of the Sea scholarship is also reflected in co-edited works, including co-editing with myself, Alex Udelfrink, and Tim Stevens, the Oxford Handbook on the Law of the Sea. And also Karen has co-edited a really interesting collection dear to my heart called the Research Handbook on Polar Law with another great colleague of mine, David Vandersvaag. Karen is a professor at the law school in Canterbury Law School at the University of Canterbury in Christchurch, New Zealand, and has been a very strong supporter of all of our Law of the Sea activities associated with this project across 2022. So the format is that Karen's going to deliver her keynote remarks, and then we should have 10 or 15 minutes for questions. So Karen, the floor is yours. We look forward to your remarks.
Well, thank you very much, Don, for that extremely generous introduction. And I'd like to thank you, Joanna and Camille, for inviting me to speak at this event. It's a real honour to do so, particularly on the 40th anniversary of the Law of the Sea Convention. And I'd also just like to add my congratulations in terms of how the conference ran yesterday. It was a wonderful discussion, and it was great to hear so many new voices, so many new ideas, and I'm looking forward to the remaining of the conference tonight. I do have some slides, which I'm going to endeavour to share with you. So if you will just give me a moment, and I will do so. That seems to be working. So the title of my keynote tonight is UNCLOS, a Constitution for the Oceans in the Anthropocene ? 40 years on from the adoption of UNCLOS, I want to think about its status of being seminally described by Ambassador Tomiko at the final session of the negotiations 40 years ago today in December 1982 as a constitution for the oceans. As I mentioned yesterday in one of the sessions, he was not in fact the first to coin the phrase. In 1975, Elizabeth Mann-Borges used the term Constitution for the Oceans in a book chapter, and she repeated it in this article. I put a snapshot up on the slide in 1978. And in both of those, she was referring to UNCLOS, or what would become UNCLOS, as an instrument, as a constitution. Since then, describing UNCLOS as a constitution is standard practice in textbooks, articles, and lectures, with or without thought as to what the term means in the context of the Law of the Sea or what the implications are. As demonstrated by a crude Google search a couple of days ago, there are 38,000 hits for the phrase Constitution for the Oceans. So is UNCLOS a constitution for the oceans, and why does it matter? Well, I'm actually only going to address the first part of that question quite briefly, mindful of the excellent paper we had yesterday from Rhys Lewis, titled Developing a Constitutional Approach to the Constitution of the Oceans. And I am, in fact, much more interested in the second part of the question, why does it matter? Overwhelmingly, in the literature and indeed in statements made by states and international organisations describing UNCLOS as a constitution, it's regarded as a positive label with positive effects. But I'm not so sure. In this lecture, I'm going to argue that describing and, more importantly, treating UNCLOS as a constitution for the oceans is in fact potentially limiting and will prevent UNCLOS and the law of the sea more generally evolving to meet the challenges of our new geological epoch, the Anthropocene. So what makes UNCLOS a constitution for the oceans? Well, the phrase, as Don noted yesterday, is not used anywhere within UNCLOS. But the fourth preamble to the convention reads, recognising the desirability of establishing through this convention, with due regard for the sovereignty of all states, a legal order for the seas and oceans, which will facilitate international communication and will promote the peaceful uses of seas and oceans, the equitable and efficient utilisation of their resources, the conservation of their living resources, and the study, protection and preservation of the marine environment. According to the Virginia commentary, this is in many respects the most important and most substantive of the preambular paragraphs. In effect, it sets the convention up as a constitution, that's the phrase they will use, or the word they use, so to speak, for the seas, a general code of conduct for states in maritime spaces, and in doing so it lays down an order of priorities for the different uses and interests involved and to be reconciled. Some scholars, and arguably Tomiko himself, base the idea that UNCLOS is a constitution on the breadth and comprehensive nature of the treaty, the idea that it is meant to govern all uses and indeed abuses of the oceans. And this is arguably consistent with preambular paragraph 4 and the Virginia commentary interpretation on it. Others focus on cautious analogies with domestic constitutions and the fact that UNCLOS sets out a fundamental set of general rules that are universally applicable, and Robin Churchill takes this approach. Shirley Scott, in what I think is one of the best analyses of UNCLOS as a constitution, which was drawn on heavily by Rhys yesterday, takes the framework developed by Bardo Fashender in respect of the UN Charter and applies it to UNCLOS. She concludes that UNCLOS undoubtedly has a complex system of governance, both in terms of substance and, of course, process. It can certainly be characterised as a constitutional moment or milestone in the law of the sea, and this, of course, is acknowledged in its preamble. And it is of practical, universal application. Of course, it's not entirely universal. The US, Turkey, Colombia, a handful of states are not party to UNCLOS, but in broad terms, it is of universal application. It does designate a hierarchy of norms, although it does not automatically prevail over other conflicting agreements in the way that the UN Charter does, outside of the Geneva Conventions and the law of the sea. And of course, finally, it is notoriously difficult to change, at least via a formal amendment process. So we might describe it as entrenched. But whether UNCLOS is a constitution by one definition or another doesn't really matter for the purposes of my lecture. The appellation is used by scholars and by states in defence of the UNCLOS status quo. And this, of course, can be an extremely positive attribute when, for example, it is used to defend against claims to be considered excessive or illegitimate, as in the case of the South China Sea, or where a state is not living up to its obligations under UNCLOS, such as those to consult, as in the case of the Chagos Islands dispute between the UK and Mauritius. But it can also be negative when it is used to prevent or stymie necessary change. And I'm going to come on to a few examples of where I think that's occurred a little bit later on in my lecture. What I'm not arguing is that comprising and being treated as a constitution means that UNCLOS can never change. It is undoubtedly a living and indeed a dynamic treaty, a point made forcibly by Judge Luckey in a separate opinion on the SRFC advisory opinion case in 2015. While its formal amendment provisions have never been used, and there is general agreement that they are unlikely to be ever used, and while its meeting of the parties has thus far not dealt with substantive issues in the way that we're used to in other fields, such as in international environmental law or human rights, UNCLOS has evolved significantly over the last 40 years. So how, in spite of, or perhaps because of its constitutional status, have we evolved UNCLOS and the law of the sea more generally? And given my critique of the term constitutional, I think it's worth just pausing briefly on the different ways in which amendment or at least evolution has taken place. I think there's at least 12. So starting off with fairly straightforward amendment, not through the formal procedures, but essentially via an external instrument, the 1994 Implementation Agreement. The adoption of subsidiary agreements, of course, have been really important in this respect. So the 1995 Fish Stocks Agreement and potentially, fingers crossed, BBNJ in 2023. Very importantly, the incorporation of so-called generally accepted international rules and standards, essentially standards derived under other instruments, which are integral to the operation of Part 12 of the Convention and also Article 94. We also have what you might describe as some quasi-legal developments. So the meeting of the parties, whilst it's done little of substance, it did adopt in 2001 a decision which granted a 10-year extension, which allows states to submit data to the Commission on the Limits of the Continental Shelf, in effect modifying Article 4 of Annex 2 of UNCLOS, and this is reflected in the CLCS Rules of Procedure. Similarly, you have quasi-legislative developments by the International Seabed Authority and essentially the development of the Mining Code. At number 6, interpretation of UNCLOS, very important in light of other principles. I've just put one example there, the precautionary principle, but there are others we could identify. At number 7, judicial activism. Perhaps one of the most important judicial developments over the last few years is the development of an overarching standard of due diligence associated with no harm type obligations. But of course, ICLOS also created essentially an advisory jurisdiction, an advisory opinion jurisdiction, which does not exist in UNCLOS outside of the deep sea bed context. This, of course, was used in 2015 in case number 21, but it looks as though we may well be using it again in the next couple of years in respect of a climate change advisory opinion. And then, of course, we have external bodies and treaties, which nevertheless play a very important role, at least evolving in the law of the sea, if not perhaps UNCLOS proper. So UN General Assembly resolutions, there's of course an annual one on oceans and the law of the sea, but the example I've given here is 71, which of course adopted the Sustainable Development Goals and of course relevant here SDG 14. Gaps in UNCLOS have been addressed by freestanding treaties such as the SUA Conventions for the Suppression of Unlawful Acts at Sea. Other areas of international law, particularly international environmental law, human rights, trade law, have also addressed gaps or enhanced general principles of the law of the sea. And then we come on to soft law, informal or unconventional sources, and I was very privileged to be part of a wonderful project led by Natalie Klein over the last couple of years looking at unconventional sources, and a very significant book in terms of length came out demonstrating the expanse and breadth of those sources. And then of course practice, which perhaps does not amount to customary international law, but nevertheless is important. Examples of the Proliferation Security Initiative and the Contact Group on Piracy off the coast of Somalia. And thank you to Rob, who I see is on the call, whose wonderful article I recently read identifying those examples. So I think what we can say that there is no limit really, or at least there are a large number of options for evolving the law of the sea, and it has evolved. So the issue is not really characterising UNCLOS as a constitution precludes amendment, change or evolution. It's that those changes are necessarily incremental. They are fixes, so to speak, to address gaps, to deal with emerging technologies or new issues. But what if we want to change the fundamentals of UNCLOS or the law of the sea? And it's transformational change, which is limited by UNCLOS as an actual, or just as importantly, as a perceived constitution. And I want to very briefly illustrate this with 4 examples of where I see the UNCLOS as a constitution as either actually or potentially operating as an inhibitor. My first example is sea level rise and fixing maritime boundaries and baselines, an issue which has exercised many minds on this call, in addition to others. And of course, it has received very significant attention from bodies, including the ILA, the ILC, as well as states. There is growing consensus that we need to find a solution, even if it's only an interim solution, for the potentially damaging implications of sea level rise for Pacific Island states or other vulnerable low-lying states. Now, this is an issue that can potentially be resolved within the UNCLOS constitution through incremental development via interpretation, practice, or perhaps the adoption of an instrument. But developing a global solution is not, I think, necessarily easy or indeed inevitable. While there appears to be a high level of support for fixing baselines or maritime boundaries for Pacific Island states, it's notable that the global discussion and the support that is expressed takes place very much in that regional context. It's not apparent from the statements made by states that solutions departing from the UNCLOS constitution are necessarily globally applicable outside of the Pacific context, when arguably there will be more political tensions and clear winners and losers from changes in geographic boundaries. And this is notwithstanding that, as Elizabeth de Lowry wrote in 2015, if there is any agreement about climate change, it is that our planetary future is becoming more oceanic. Sea level rise is perhaps our greatest sign of planetary change. So we're going to need to do more than fix a few baselines in our future oceanic world. My second example is the BBNJ agreement, perhaps the most significant agreement for ocean resources, or potentially even any resources since the adoption of UNCLOS itself 40 years ago. Yet the UNCLOS constitution has operated as a constraint on the potential of what might be achieved by that agreement. It has been confined by the principles, values, processes and institutions of UNCLOS. And should it be adopted in 2023, it will be an incremental evolution of the law of the sea at best. And there's a very real question about whether it will be sufficient to address the challenges of the next 40 years. And I'll say a little bit more of that later on in my lecture. My third example is France's call on the 10th of November this year to the International Seabed Authority to ban seabed mining. France had made a statement earlier in November at COP27 and indicated that it intends to defend its position in multiple international forums. France stated that its commitment is simply a reflection of the sentiment of urgency and major concern that we are all experiencing, faced with the need to protect the ocean and with it humanity. France received some support from the states of Micronesia, and Micronesia has, of course, joined the Alliance of Countries for a Deep Sea Bed Mining Moratorium among Pacific states, including New Zealand, but it's notable that group of states have taken a slightly softer position, calling for a moratorium until robust and effective rules are agreed. But outside of that, there was notable pushback from other states, including the Cook Islands, Poland, Norway, and indirectly the Secretary General of the International Seabed Authority, Michael Lodge, against France's position. And all of those statements pushing back emphasise the importance of the integrity of UNCLOS, arguably implicitly invoking its constitutional status. Finally, the freedom to fish, a core constitutional principle, if you like. Now, some would argue that this perhaps has already been eroded to the point of irrelevance in light of the adoption of the FSA and developments within the RFMOs, but I would suggest that that's not the case. The starting point in any governance discussion about fisheries management is the freedom to fish and what are acceptable constraints on that freedom in light of stock status and, of course, the principle of optimum utilisation. But given that it's been widely predicted by 2050, the weight of plastics in the ocean will exceed the weight of fish, should the principle of the freedom to fish be our starting point in any discussion on fisheries management? The obvious question to ask is whether UNCLOS as a constitution for the oceans can facilitate transformational as well as incremental change. In 1992, Philip Allott answered this question in the affirmative. In his seminal article, Mare Nostrum, A New International Law of the Sea, published in the American Journal of International Law a decade after the adoption of UNCLOS, but before its entry into force and the adoption of the 1994 agreement, he argued that the convention is a slow motion metamorphosis. In the 1982 convention, a particular structure of international social organization is reforming itself, undergoing a process of structure metamorphosis. It is a half-formed new structural uniqueness, full of painful ambiguities and exciting possibilities, full of the inharmonious harmony that is fitted for the growth of life. He argued that while the genetic inheritance of traditional law is found in the property relation ethos of the convention and the emphasis on state-to-state relations, and indeed what he described a decade earlier, also in the American Journal of International Law, as a convention comprising a massive structure of powers, UNCLOS nevertheless contained 4 principles which contained within them the potential to emerge, as if from a chrysalis, as the new law of the sea. But 40 years on from the adoption of UNCLOS and 30 years on from the publication of Philip Allott's article in the American Journal of International Law, I think we could argue that not one of those principles has lived up to its potential to lead to a metamorphosis in the law of the sea. Take principle 1, which focuses on integration and can obviously be found in the preamble of UNCLOS. Some might suggest, perhaps only a little unfairly, that integration has been confined only to the preamble of UNCLOS. But UNCLOS undoubtedly adopts a zonal and a sectoral approach, and neither can be defined as promoting integration. And the separation of fisheries from marine environmental protection is just one example of disintegration from very early on. Now, over 40 years, significant attempts have been made to promote a more integrated approach, something that I have worked on previously, but it has proven immensely challenging. And in part, that challenge is owing to the structure and the constitution of the law of the sea as embodied by UNCLOS. Principle 2 suggests a departure from the traditional relationship of property towards a relationship of participation in the convention. And Allott suggests that this principle is exemplified by the Part 11 regime, as well as the new regime for the EEZ, which he suggests is more than an accumulation of bilateral relationships. Both examples are open to challenge, but I'm just going to stick to the deep sea bed owing to time. While the deep sea bed regime was undoubtedly a radical departure from a traditional sovereignty approach, it was substantively diminished through the 1994 agreement to the clear detriment of the participation of developing states. Today, one might argue that the ISA has been captured by traditional mining interests with very traditional approaches to property. And more importantly, but little remarked on, is that rather than developing states engaging in mining in reserved areas, companies in developed states have set up wholly owned subsidiaries in developing states and have thus obtained contracts within the reserved areas. The metals company in Canada owns the Nauru Ocean Resources and the Tonga offshore mining and Marawa in Kiribati, and thus effectively has contracts sponsored by Nauru, Tonga and Kiribati. And this certainly does not, in practice, represent increased participation in or indeed substantive benefit to developing countries. Principles 3 and 4 have arguably had greater success in that states have by and large mediated their claims and disputes through the UNCLOS framework. But of course, we have seen a more recent worrying trends of certain states refusing to appear or to comply with judicial decisions. China and Russia are the obvious states which spring to mind, but one could also identify the UK in respect of the Chagos dispute, although it now does appear that the UK is sitting down with Mauritius in order to try to resolve the dispute over the archipelago. China, of course, appears to be maintaining a broader argument disputing the applicability of the UNCLOS constitution to the South China Sea. So I would argue that UNCLOS has not facilitated a metamorphosis of the law of the sea, or at least not a metamorphosis that is capable of addressing the challenges of the next 40 years. So why is this? Well, UNCLOS is the product of the Holocene and of Holocene thinking. Increasingly, there is a move to contrast the Holocene with the Anthropocene and to argue that we have moved from the Holocene, which began around 10,000 years ago, into the Anthropocene, which began, although not everybody agrees with the date, around 1950, the beginning of the nuclear age. The Anthropocene was not officially recognized as a new epoch, describes an age where the relationship between humans and nature has changed and where humans have remade nature in ways that previously only occurred as a result of geological forces. But the Anthropocene is not simply a description of a geological epoch. It is not merely shorthand to describe fundamental human-induced environmental change. Its development is as much ideological as it is scientific. It's a way of understanding our world, and in the words of Jay Baskin, a normative guide to action. From a political policy and legal perspective, thinking about the Holocene and Anthropocene can provide a valuable lens through which to view our assumptions on which we have built our regimes and institutions. Crucially, two of those assumptions underpin the law of the sea and its constitutions, and they are environmental stability and perpetual economic growth. Now, of course, those assumptions, in fact, underpin the international legal system more generally, but that is a lecture for another day. The Holocene was characterized by remarkable environmental stability over the last 10,000 years, and that assumption of environmental stability underpins the approach of UNCLOS to maritime zones and baselines, to the allocations of rights and duties within and beyond those zones. But if we are entering a period of much greater environmental instability, in particular where rising sea levels have the potential to remake geography, is UNCLOS able to respond? This environmental stability of the Holocene has also allowed, over the last 400 years or so, for international relations and law to be dominated by states. And the law of the sea, as articulated in its constitution, is highly state-based. Now, we've already seen challenges to this through increasing recognition of the rights of Indigenous peoples and individuals on the seas. The adoption of the Geneva Declaration on the Rights of People at Sea was an important step earlier this year. But as states become less stable and its interests proliferate beyond the nation state, is UNCLOS in a position to respond? The second assumption of the Holocene is that of perpetual economic growth and the implications of that growth for approaches to property and economic policy. We have tried unsuccessfully to address and limit growth through the concept of sustainable development, but sustainable development is still built on the assumption of Holocene growth. UNCLOS is built on assumptions of growth. In the words of Sabari Rangathan, the law of the sea, represented preeminently by UNCLOS, establishes an extractive imagery of the ocean. In her chapter in the recently released edited collection by Iris Braverman, she cogently argues that the UNCLOS constitution for the oceans is largely about extraction. And that is evidenced from the division of ocean spaces and the consequent allocation of rights to coastal and other states, in the principle of optimum utilization and fisheries management, and importantly, by linking exploitation, especially of seabed minerals, with a greater utopian vision of world order. Iris Braverman and Elizabeth Johnson take a similar view in the introduction to their recent edited collection, Blue Legalities, The Life and Laws of the Sea. On the one hand, the seas are configured as a global commons. On the other hand, they are perceived as providing a repository of globally profitable commodities. This tension has long underpinned the establishment and negotiation of marine spaces and its corresponding legalities. One can argue, one can argue that notwithstanding the very many positive developments relating to the environment and fishing over the 40 years, which I fully acknowledge, post-UNCLOS instruments remain confined within the extraction imagery. This is clearly the case for the Fish Stocks Agreement, but also appears to be the case with the BBNJ Agreement, which is very much about the extraction of MGRs and confining MPAs and EIAs in ways that do not undermine existing regimes relating to fishing and other ocean activities. Led by critical legal scholars, but gradually becoming increasingly mainstream, there is a recognition that the law of the sea needs to be reimagined if it is to respond to the challenges of the Anthropocene, and the changes in the law of the sea must be transformational rather than merely incremental. Iris Braverman and Elizabeth Johnson write, like climate change, the governance of the ocean is a wicked problem. But while altering ocean management is absolutely crucial, especially in the face of growing ecological crises in the Anthropocene, we must at the same time acknowledge that it requires radical rethinking, both of our existing assumptions and of our existing institutions and regulatory apparatuses. Now, the purpose of this lecture is not to engage in that reimagination, although it will probably involve rethinking our relationship with the marine environment, including the land-sea interface, reconceiving equity amongst states and peoples, particularly in light of environmental and geographic changes, and rebalancing traditional freedoms, including the freedom to fish, with other considerations, particularly environmental considerations. But rather, my question is whether we can even begin to engage in that reimagination while recognising that UNCLOS is an actual or even a perceived constitution for the oceans. My instinct is that we can't. However Tommy Coe intended his remarks, the appellation has become something of a straitjacket for UNCLOS. Characterising UNCLOS as a constitution for the oceans can undoubtedly be a force for good. It can be used to support and strengthen UNCLOS principles when they're under pressure or even under attack by states who wish to operate outside of the regime in a national rather than an international interest. But equally, this characterisation can be used to inhibit or even prevent evolution of the regime. And we're already seeing this occur in the ISA and the BBNJ negotiations, and I would suggest in the engagement of the law of the sea with climate change. If we go back to the Virginia commentary on the 4th preambular paragraph, which I quoted earlier, it says that the paragraph sets the convention up as a constitution, and in doing so lays down an order of priorities for the different uses and interests to be reconciled. And the order of those interests in the preamble promotes the utilisation of resources above conservation and environmental protection. But maybe we want a different order of priorities today. I'm not advocating in any way that we jettison UNCLOS itself. It was a remarkable regime when adopted 40 years ago, and it remains in many ways remarkable today. It's often said, correctly, in my opinion, that if we were starting again today, it would be impossible to replicate the negotiation of UNCLOS. But I would add, would we want to replicate UNCLOS today? Or would we actually want to do something different? So I'm arguing that we abandon the label, the idea, or even the perception that UNCLOS is a constitution for the oceans, and we jettison the straitjacket that this label has become. We should treat UNCLOS with respect, but not with reverence. UNCLOS can and should evolve, and we should not be constrained by principles and concepts that were frankly developed not simply in a previous century, but which have their origins in a different epoch. Thank you very much.
Thank you so much, Karen, for that very rich, wide-ranging and very challenging keynote address for our conference, and a very apt address given the time and the way in which we're trying to look forward into the future. Colleagues, we have about 15 minutes for questions, so I have questions myself, but I'm not going to abuse my privilege on this occasion as chair. So I'm going to open it up to anyone who wants to put up their hand in the normal way online, and we'll take it from there. So over to you, Joanna.
Hi, Karen. Thanks very much for a really thought-provoking lecture. Just reflecting on the first of the principles that Philip Allott mentioned, I thought it quite interesting to see that among the principles that are potentially going to be included in the BBNJ treaty is the principle of integration, which I find quite interesting because no one's really talked about what it actually might mean in practice. And yet there seems to be no debate about whether or not it would actually be included. And I wonder if you had any thoughts about, what that might mean, whether it might mean that integration is going to take a higher sort of role, although given the structure of BBNJ, it's possibly a little doubtful that that's going to be possible.
I'll go to you now, Rob, for your question.
Thanks, Karen. That was fascinating. I guess my question's very, very simple in this respect. is there a risk that if we reduce the constitutionality, so to speak, of the convention, and we start to think about how do we get something, move this forward in the direction where it needs to go, but is the risk that in reducing the constitutionality, the agents that are going to do any moving forward, states, will actually drag it backwards? And, you know, their interests are not necessarily, because they're short-sighted, the interests that you're looking at here.
Thank you, Joanna and Rob. We'll leave it at that for the moment. Karen?
Well, thank you very much for both questions. Joanna, in relation to integration, yes, I think it's certainly positive that it's listed there as a principle, but I don't really know what it means in the context of the BB&J. I think one of the really important features of integration, where there have been genuine attempts to implement it, so in areas such as the Mediterranean, is that you need meaningful coordination amongst institutions and regimes. And I think it's far from clear as to whether that would able to be facilitated by the BB&J. And I think you said yourself in other presentations that you think the success of the BB&J is going to come down very much kind of to those institutions within the BB&J agreement. And if integration is to have sort of any chance at all, it would absolutely come down to those institutions. I mean, an obvious problem right from the outset is that it would appear to be the BB&J is not going to address fisheries. So excluding such an important activity immediately means that sort of integration is limited. So it's great that it's there, but I'm also unsure as to kind of what it means in a sort of a meaningful way. But to be fair to the BB&J agreement, it's been, you know, it's included in quite a lot of regional instruments. It's really hard to attempt to actually implement it in a way that is meaningful, and it's actually hard at a domestic level. I think most states would agree with that. Rob, I absolutely agree. I suppose what I'm sort of saying is that, you know, one should sort of open up UNCLOS, whether one uses the formal amendment procedure or not, and therefore to do that inevitably creates a risk. So yes, there's no doubt that if one departs or perhaps reduces the importance of those constitutional principles, then you are potentially opening up to states such as China to say, well, we actually want to do something different outside of the regime in the South China Sea, as just for an example. So I wouldn't in any way disagree with that. I think that's a risk. The problem, though, is that my instinct is that we need to not break, but we need to think about different approaches in relation to how we're going to manage the law of the sea in the future. I had the good fortune of attending a sort of a book launch in Australia by Robin Churchill a few weeks ago, and he started off informally by thinking about the time between the editions of his book and kind of speculated that the next edition would be out in 2060, and that led to a bit of a discussion as to what the law of the sea would look like in 2060. And it was just quite fascinating. It was an organic thing, but we sort of saying, well, there would be kind of no oil, so no kind of interest in the continental shelf. Ships would look very different. There'd be no fish in the sea. So there's a sense that, you know, the challenges are very real, and it's going to be quite different from the context within which the negotiation has taken place. So how do we try to move towards that? But I share your concern in terms of risks, absolutely.
A final round of questions. Quick questions, please, from Reese, and then Greg, and then Merrin. So Reese, you're first.
Yeah, my first would be in relation to you described the principles and you concentrate on the preamble. And what I tried to do in my paper was suggest that there are alternative principles, and it doesn't have to be through the preamble. So I suppose my question relates to help me in a way. Where do you think these principles should be when we look at the interpretation of the Constitution? I don't think it has to always be in the preamble, but within the spirit of the convention, and that those key values could be interpreted in the modern way. I suppose it would be a difference of constitutional approach, a sort of Justice Breyer kind of approach would be one I would adopt, whereas it sounds like you're suggesting a almost originalist approach to the Constitution is what we have today. And I don't think that that has to be the case. I just would be really interested in your thoughts on that. Thank you.
Thanks, Rhys. Greg?
Thank you, Don. Thank you for organising the conference, and thank you, Karen, for a fascinating paper that I learned a lot from. And I appreciate your insights. My question is not so much a question as a comment about the Iris Braverman and Elizabeth Johnson Blue Legalities position, where they juxtapose the extractive approach with the commons, whereas the commons, as I understand it, and I'm not sure that they understand it that way, is itself an extractive principle. The res communis was something that everybody could extract from, to the point where you had the tragedy of the commons. So in fact, it's not a contrast, but the same extractive principle. So more a comment on the source. Thank you.
Thanks, Greg. Marion?
Thanks, Don, and thanks so much for that, Karen. I was interested if you, on your further thoughts on the sea level rise issue and the move from the Pacific Islands to set their baselines in light of forthcoming environmental changes. What do you think it would take, or what do you think some of the challenges are going to be in building consensus on that interpretation of UNCLOS in the next couple of decades?
Well, thank you very much to all those questions. Starting with Rhys, I highlighted the preamble because, of course, there's no reference to UNCLOS as a constitution within the text of the instrument, and the Virginia commentaries refer to constitution in the context of that fourth preambular paragraph. But that certainly isn't to suggest that I'm thinking that its constitutional status comes from that preambular paragraph. So I would regard it as certainly much broader than the paragraph, and the Constitution for me comes through its processes, its core principles, throughout the entire instrument. So can you interpret it in a modern way? Yes. I mean, I don't in any way dispute that, and of course interpretation was sort of through my mechanisms of change in a couple of ways. So I think I absolutely agree with you that a constitution does not prevent incremental development. It does not prevent interpretation, which can address some of these issues. So I think my argument is more that if you're actually wanting to do something quite different, you're wanting to identify different values, then at that point, characterizing it as a constitution as something which is more challenging to change becomes a problem. And I suppose a domestic analogy would of course be the United States and the right to bear arms. So you can sort of see the constitutional arguments associated with that, which and it's certainly not just the Constitution, but of course it can make substantive change quite difficult. So just to clarify, I kind of highlighted the preamble because that's really the only official place that even the Virginia commentaries kind of refer to Constitution, but I'm not in any way suggesting that that's the only where we get it from. So I hope that's clarified that. Greg, yes, I agree with you entirely. I essentially took my agreement with Iris Braverman and Elizabeth Johnson is in that UNCLOS establishes an extractive regime. I fully agree that a commons regime does not in any way preclude extraction, as we can see from fisheries and indeed from the deep sea. So I would not subscribe to the idea of a commons as being not extractive. But I would nevertheless suggest that we need to move away from purely extractive in the current context. And Marion, that's quite a big question, and I know that there are some people on the call that have been doing some work on sea level rise, and in particular the work in the Pacific. Interestingly, of sort of the examples I gave, I think this is probably the one I would have most hope for as developing within the UNCLOS constitution. of all the examples I gave, because there is increasing consensus. I don't think it's going to be particularly hard to get something which will essentially fix either baselines or maritime limits with respect to Pacific Island states. The question I have is developing a global solution. And this is because whilst I think there's general agreement that Pacific Island states are general losers from rising sea levels, and to fix their baselines doesn't really create other losers, that isn't the case elsewhere. Where you have contentious maritime boundaries and claims, there will be winners and losers with geographic changes. So in other parts of the world, I can imagine that there may well not be quite such enthusiasm for fixing boundaries. And of course, should sea level rise happen in a very extensive way, and I suppose we're looking more than 40 years, hopefully more than 40 years into the future, but looking at a very long time in the future, then that would lead to very significant changes. So in terms of sort of building consensus, I mean, I think the work of the ILC, I know a lot of states are working with the Pacific, including Australia and New Zealand, and I know that there are discussions that are going on in New York, so I think sort of those sorts of discussions are going to build consensus. So as I say, interestingly, of my examples, I think that we could probably manage that within the current constitution, at least to that limited extent. Thank you.
Colleagues, I think we might bring this session to a close. Before we thank Karen once again, our next session is scheduled to commence at 6 o'clock Canberra time. For those of you who wish to attend panel 4A, Technology and the Anthropocene, this Zoom link will remain active. If you want to go into panel 4B, the LOSC and New Energy Futures, you'll need to select the other Zoom link. And just a reminder, we've got panel 4, then panel 5, and then we will reconvene at 8:15 Canberra time for some closing remarks. But colleagues, I'm sure you'll agree with me, we've been really privileged today to hear a very thoughtful, very rich, very stimulating set of remarks from Karen, very apt set of remarks given today and its significance being the 40th anniversary of the Law of the Sea. I'm sorry to disappoint you, Karen. I did go looking for a birthday cake, but they didn't specialise in Law of the Sea convention birthday cakes in Canberra today, much to my disappointment. So please join me in thanking Karen.